This case today is 1CA CV18 0278 Trap Zap versus FacilitySource. These proceedings are being audio and video recorded, so we would ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Mr. Brophy, I'm advising you that you are responsible for watching the clock and reserving any portion of your time for rebuttal if you so choose. We have read the briefs. We've discussed this case this morning at conference. And Mr. Brophy, you may proceed.
Thank you and good morning. I'd like to start off with a bit of housekeeping. There is a discrepancy in the briefing regarding the amount of money at stake. Our opening brief identifies the amount as $194,881.48. TrapZap correctly points out in its answering brief that the actual number is $161,744.38. So that's a mea culpa on my part. I didn't make up the $194,000 number. There was a reason behind it. It's just that I forgot there was a section of the claim resolved before appeal. The question presented for this court is whether the Arizona courts will allow an unlicensed or access to the Arizona courts for unlicensed contractors who performed work in another state when the courts of that same state will not allow similarly situated plaintiffs access to those courts for payment for unlicensed work.
Your agreement says that Arizona law governs, correct?
That's correct. And so the first issue that the court has to address is the application of that choice of law provision. Arizona, generally speaking, will enforce a choice of law provision. But under the Landy and Cardin decisions, which both adopted the restatement second conflict of laws section 187, one of the exceptions to the rules is if to enforce the choice of law provision would violate the fundamental public policy of another state with a materially greater interest in whatever the issue is.
So why don't we pause and go back to the beginning? Your client is the Arizona resident, correct?
Correct.
And your client negotiated to use Arizona law in this contract negotiation, correct?
Correct.
And now your client is the one that's arguing some other state's law should govern, is that correct?
It is not that another state's law would govern the entire contract. It's just that for issues, if to enforce the choice of law provision would violate the fundamental public policy of the state with a materially greater interest.
Or that state?
That state.
Now, when we talk about that state, what state are we talking about?
Any one of the three at issue, which would be Delaware, New York, or New Jersey,
So
which is where the work was performed.
And I'm aware.
Okay.
But I just want to make sure that I understand in my mind what you're asking this court to do. So you're asking us to disregard your client's choice of law provision in regard to the public policies of three other states and apply three different state laws to this provision of the contract. Not
to that provision. The choice of law provision would be otherwise applicable.
Okay.
It would only and it's not even, well, yes it is. Yes, to apply not so much the laws of the other state, but just to recognize that that Arizona cannot be a party to basically opening up our courts to litigants that performed work in another state when that state has made a decision. And I would argue that this would go to the fundamental nature of the public policy, where they feel so strongly about this that they deny similarly situated plaintiffs access to their courts for exactly this reason.
So you're not really asking for the law of the other states to apply. You're asking that Arizona law be applied in a particular way. Because as I understand it, the outcome that you want is that under Arizona law, if the party is acting unlicensed in the other state, then that makes the contract illegal under Arizona law.
Yeah.
rightly or wrongly, that's really not a conflict of law issue. It's just what is Arizona law on that subject.
Well, that's sort of the next step of our argument, which is that even if you did apply Arizona law, it's not like we have a different rule than those other states do with regard to this particular issue.
Well, but you're raising this, at least right now, at this moment, as a conflict of law issue.
Correct.
Whether you're right substantively on the issue you're raising, it really doesn't seem to be a conflict of law issue to me.
I'm not sure that I understand why you feel that way. Are you saying, I mean, the conflict of law issue would be decided by this court under Arizona law, determining whether the court is going to enforce the choice of law provision.
As I understand conflict of law issues, does Arizona law govern this case, or does some other state's law govern?
Arizona law governs it under the choice of law provision, but whether or not that choice of law provision gets recognized and enforced under what circumstances is decided by this court under Arizona law, which would be the Landy and Cardin decisions and restatement section 187. Does that answer your question?
Yeah.
Okay.
It seems to, as I'm looking at this case, if CAPSAT was supposed to be licensed in those other states and was not, that's simply a breach of contract, right? You're arguing the contract is illegal. At least by my reading so far, it doesn't seem to be illegal. There may be a breach, but it's not an illegal contract.
The contract on its face is not illegal, so the conduct is not inherent. It's not like a contract to deal drugs or something like that. But the conduct that they're asking to be paid for is illegal under the laws of those states.
But that just means that CAPSAT may have breached the contract.
Well, they've done that as well, because there is a contract provision that requires them to make sure they have all appropriate licenses.
The conduct is not illegal. It's not illegal to get grease, to dispose of grease.
It is to run a business and do that without a license.
Well, then it's doing the conduct without a license. So you keep saying the conduct is illegal, and it's not. It's not illegal. It's to do so without a license, which then says, Judge, was that a breach? And if it's so, how was it hurt? How does your client hurt? All of those customers paid. So you're asking us to give your company a $161,000 windfall, right?
You can call it a windfall, and
you can call it whatever you want.
Yeah.
It's still a windfall.
Well, yes, and that's done all the time. There's case law from each one of the states that are at issue, and there's also case law from Arizona under, I believe it's ARS 321152. We have a similar provision in statute, and what clearly goes through the cases is the issue when it comes to when there's a statute passed for the health, safety, and welfare of the people of whatever jurisdiction there is, that takes whatever windfall there might be takes a back seat to whatever the health and safety or protections are at issue. This court said, I believe it was last year in the Levine case, which dealt with a fee agreement for a lawyer, there was some language in there that just said you can avoid this problem by just doing what you're supposed to do, and in this case it would be getting the license. I'm sorry.
No, it's okay. I just didn't want to lose my thought. Right. Sorry to interrupt you. How do you rectify the difference between Levine and Mountain States Bolt, Nut, and Screw Company? You've got a trucker there that doesn't have a license to transport partway through our state, so they're unlicensed for a part of the job they're doing. And the court said, nope, you can collect under that. Levine, you're talking about an unlicensed private investigator, a lawyer who is accepting fee agreements. I mean, the Levine case is much different than business people entering into a contract. Somebody lacks a license but completes the work satisfactorily, and our court in Arizona said, you got to pay them.
That is true in the case of Mountain States, but the line that makes all of those cases consistent, whether it be San Filippo with the medical treatment, nobody thought that whatever the physical therapy was that was done in that case was done incompetently, or whatever the work the private investigators did, I believe was in Landy, that was substandard. When the licensing requirement is in place for the health or safety of the public, as opposed to maybe it's an administrative fee where the government's just raising money, then that is when you see forfeiture of whatever the work was done, regardless of whether...
States that the requirement that certain truckers have licenses is not health and safety?
That was not that concept, and the reason for reaching the decision. None of those concepts were raised by the court. I mean, I don't know if we could have a conversation about that today. All I'm saying is the court in Mountain
Well, no,
State.
I asked you. Do you believe that the regulation? It seems to me is self-evident that it was for health and safety.
I don't know the statute.
Why else do you regulate people that are engaged in long-haul trucking? Why else do you regulate contractors? Why else do you regulate people that are collecting grease out of a restaurant? Public health, welfare, and safety. I mean, what other reason would there be?
Well, if that's the case, if that wasn't the finding, then suddenly it becomes difficult to reconcile Mountain States with the other four cases, San Filippo, Landy, Levine, and I know I'm missing one, but I can't think of it off the top of my head. If that's not the difference, then I would struggle to find what the difference is that makes all of those cases fit together. I just submit to the court that a finding that a statute is for the health, safety, welfare of the people is the only thing that synthesizes all those cases and makes them make sense.
Track that may expose itself to some sort of regulatory punishment in those other states for not having a license. But I don't understand why there potential punishment in those states for working with a license means that you don't get you're not required to pay them for the work that they did for you.
For the
It's not like...
For the same reason this and all these other states refuse to allow plaintiffs to collect payment in similar situations, and it's this. If you're running around doing unlicensed contracting, the only time it's ever going to come to the attention of the government is when it's too late and somebody's been victimized. A policy like the one that we're advocating here today is a deterrent because it's a way to get at people that the government has not yet detected, that are operating without a license, and now when they come knocking at the courthouse door and they don't have one, they're cut off.
And your client just so happens to benefit from that.
That's true.
That's fine.
Excuse me?
That's fine. I wonder about the public policy behind that.
And that is addressed in some of our cases and in some of the out-of-state cases. And the public policy is, it's not that, look, I'm not going to sit here and tell you that it's not a windfall. It's just, the only thing that I'm saying is that the case law consistently says there's a higher priority than whether or not somebody received a windfall.
Are you waiting just for a gotcha moment? Like maybe there was a technical violation, and that's why they didn't have a particular license in a particular case, and all of a sudden we're supposed to look the other way and give your client a $161,000 windfall?
You could make the case that by allowing the contract to go forward is also looking the other way. I mean, that certainly seems to be what some of the courts have said.
It seems to me like both parties got the benefit of the bargain. You got the benefit of their work, and they got the benefit of the payments that you were supposed to make to them.
That's correct, but I would just submit that...
and isn't the problem that comes from allowing unlicensed work properly resolved not by dinging traps up by not paying them, but facing whatever regulatory punishment exists in those states. I mean, perhaps you should report traps up to the appropriate authorities in those states. That seems to be a more appropriate punishment than having them do honest work and not get paid for it.
And again, under our similar case law, under 32-1151, There's a lot of talk about this from this court and the Supreme Court talking about that if you want to really address this problem, go out and get licensed. And, you know, I'm not aware of any case law that says, well, they normally wouldn't be entitled to get paid, but as long as you reported them, then, I mean, that's not a factor that's ever really been considered by.
But I mean, I guess it's not, at least where I'm looking at it, is whether parties are properly licensed in other states. It's really not the business of Arizona, it's the business of those other states. And if you have an otherwise valid contract and everybody does get the benefit of the bargain in Arizona, what happens in those states stays in those states.
I think I tend to agree with you that Arizona, it sounds to me like what you're saying is Arizona really doesn't have a dog in this fight. And that's correct, which is why, under the restatement Landon and Carty, you don't enforce the choice of law provision, because those states have a problem with what happened.
And those states have a remedy to address it. When you talk about Arizona not having a dog in this fight, Arizona is a business-friendly state where we hold people to their contractual obligations. You don't think that is a public policy worth upholding?
I do, but I also think that the briefing has 4 Arizona cases where this court has said there's an exception to that rule under similar circumstances where people performed perfectly good work, but because they did something that was illegal against public policy, this court wouldn't allow an award of whatever damages they were seeking. I'd like to reserve the rest of my time for rebuttal unless anybody has any pressing questions.
All right. Thank you very much,
Thank
Mr.
you.
Brophy. Counsel.
Good morning, and may it please the court. My name is Bradley Pack, and I am appearing today on behalf of the appellee and cross-appellant TrapZap Environmental Services. Good morning to our legislative interns as well. There are actually 2 issues that are in front of the court today. One, obviously, is the issue that FS&E has raised on its appeal concerning their allegations of illegality. The second is TrapZap's cross-appeal concerning the applicability of the Arizona Prompt Payment Act to this contract in which the parties chose Arizona law to govern. And, Your Honors, I am certainly happy to address any questions that the court has concerning the appeal, and I do intend to address those. But with the court's indulgence, I'd like to focus initially, at least, on our cross-appeal. So, again, this is a case where the parties expressly chose Arizona law to govern their relationship. In fact, it was FS&E that drafted the contract that included the Arizona choice of law provision. Having done that, FS&E is bound by Arizona law with respect to the enforcement and interpretation of the contract, and they are not free to simply disregard what parts of Arizona law are disadvantageous to them. One of the Arizona laws that applies here is the Arizona Prompt Payment Act.
How do you rectify the Arizona Prompt Payment Act with the Registrar of Contractor requirements and references to the Arizona Prompt Pay Act when your client doesn't operate a business in Arizona?
The licensing requirements for the Arizona Registrar of Contractors and the Arizona Prompt Payment Act are 2 completely separate acts, and they're addressed at separate policies. The policy behind the licensing requirements under the Registrar of Contractors Act is to protect the public. It's to make sure that the public isn't going to be harmed by people who aren't competent to perform their contracting and construction jobs. The policy behind the Prompt Payment Act is completely different. It's not focused on the protection of the public, it's focused on the protection of the people who actually perform the work. The subcontractors, the material suppliers, the people who are actually performing services and have a reasonable expectation of being paid, particularly when they are in a situation where you have a general contractor who gets paid directly by the owner for the subcontractor's work. And what the Prompt Payment Act tells you is that if the owner is getting paid, it is unfair, and we are going to impose a penalty if the owner doesn't then timely make payment to the subcontractor.
Which would make sense up until you get to ARS 32-1129-02B, that it talks about any diversion by the contractor or subcontractor constitutes grounds for disciplinary action by the registrar of contractors. Now, it's kind of turning you guys' argument on its head, because if our ROC can't discipline you or them, why should their contract in another state? Do you see what I'm saying? We've got a regulatory body that regulates, and part of it is discipline through the ROC. You say it's a construction contract, they say you're not a subcontractor, I get all that. But if the mechanism to enforce is an Arizona-specific mechanism, the ROC, why would it not just apply to work done in Arizona?
Because that's only one mechanism to enforce a statute and to ensure that subcontractors will be paid by their generals. It's not the only mechanism, and in giving parties like subcontractors a private right of action by allowing them to sue for and obtain interest at 18% per annum on their unpaid invoices, I think that the legislature was making a clear policy of saying, we're going to hold you, if you're a licensed contractor, then not paying your subs is unfair, and you're going to be subject to regulatory consequences. But even if you're not a licensed contractor and you're not subject to the ROC's jurisdiction, there's also going to be civil penalties that the people who are directly affected by your decision not to pay them can pursue on their own. And it's important here to note that there are clearly people that are within the class of being protected by the Prompt Payment Act that are not required to be licensed as contractors under Arizona law. One example of that, the Prompt Payment Act includes within the definition of work. So a construction contract is a primary definition, which is any agreement. It includes any agreement relating to the maintenance of any building, and it also includes traditional things that contractors would do, renovations, repairs, and that type of thing. But then it also defines work as including any materials or equipment supplied in connection with a contract to perform maintenance or renovation. Material suppliers are not required to be licensed by the registrar of contractors. Home Depot is a material supplier. They do supplies to construction contracts all the time. I don't think there's any requirement that they have to become a licensed contractor by the ROC. So because, in addition to that, I think the fact that the Prompt Payment Act defines construction contract and contractor and subcontractor both differently and more broadly than the licensing statute does also tells you that the intention here was not to limit the applicability of the statute just to contractors who are licensed by the ROC. If that's what the legislature wanted to do, if they wanted to limit that applicability, it would have been very easy for them to do so.
But you're saying that your client is a subcontractor, is that correct?
Yes, under the definition of the Prompt Payment Act.
Under the definition of the Prompt Payment Act. But your client is not subject as a subcontractor. Is there any other relationship in the construction trades that says subcontractor is not required to be licensed by the ROC? Or some other regulatory agency?
Your Honor, I'm not quite sure I understand the question.
You're talking about Home Depot, which
right.
You can't say that without more saving, more doing. Just saying. But you're talking about Home Depot, a material supplier. That is not the same thing as a subcontractor going out to jobs performing work. Agreed?
Agreed.
Subcontractors do work for the Home Depot, you would agree, because when I get my carpet installed, Home Depot doesn't come out and put it in for me.
Right. They may have a contract. The people who actually do the installation may have a contract with Home Depot.
The people that are in that contract are subcontracting with Home Depot, correct?
Correct.
So what are you, if you are not a subcontractor, or you are a subcontractor, but you aren't licensed in the state, I'm confused about who regulates you then.
Well, first of all, I don't think there is anybody, frankly, that regulates TRAPSAP's activities other than, the they got to pay their sales taxes like everybody else, and they're a New Jersey corporation, so they have to file their corporate reports with the New Jersey, whatever the New Jersey equivalent of the Corporation Commission is. But they're not a contractor in the sense that there's some type of special licensing requirement that applies to them. And again, I'll address that in connection with the appeal, because there's a lot of arguments. There was an inherent assumption in Mr. Brophy's argument that what we were doing was illegal or performance was illegal, which is not the case. But that fact, the fact that we're not required to be licensed by anybody, doesn't disqualify us from being a subcontractor under the definition of the Prompt Payment Act. If you're only looking at this in the sense of what's the ordinary sense of the term contractor or the sense of the term subcontractor, I think that might have some more meaning. And that is how the licensing statutes define contractor and subcontractor. They say it's synonymous with the term builder. Okay, that's probably what most of us would understand a contractor to be. But in drafting the Prompt Payment Act, the legislature specifically chose to define the term contractor and subcontractor with a very special meaning and its own special definition that is different from the definition under the general licensing statute. It is intentionally a much broader definition than you would find otherwise that applies to contractors and subs. So we're not looking at this in terms of what do ordinary people understand to be the meaning of the term contractor or subcontractor. You have
Any
to
person, firm, partnership, corporation, association, or other organization, or combination of any of them that has a direct contract with a contractor or another subcontractor to perform a portion of the work under a construction contract.
correct.
So how do you fall in there?
I think it's fairly easy. So first, contractor.
Direct contact with a contractor licensed by the ROC, another subcontractor licensed by the ROC under a construction contract governed by ROC regulations.
Well, where I would respectfully disagree with you, Your Honor, is in the insertion of regulated by the ROC or registered by the ROC. Those words simply are not in the statute, and I don't think that they can be inserted. You have to look at the statute in accordance with its plain and unambiguous meaning. And there is nothing in the definition of contractor or subcontractor that says either this has to be somebody who's licensed by the ROC or this has to be somebody who performs their work inside the state of Arizona.
So you agree that we read this whole Prompt Pay Act together, beginning to end, and we try and harmonize each part of this Prompt Pay Act. Agreed? That's how we're supposed to do statutory interpretation.
Correct.
Okay. So you have looked at subcontractor and said we should expand the definition thereof.
No, I'm not saying you should expand
You're
the
saying your
definition.
client falls under it even though there is no regulatory body in the state of Arizona that is responsible for overseeing any portion of your client's work. Okay. How do we rectify when we get to the B requirement? It says violations of this section. So violations of the sections are grounds for suspension, revocation of a license, or other disciplinary action by the registrar pursuant to, and it falls in Title 32. I mean, we're looking at the big contractor statute, we're looking at Title 32, we all know that means ROC claims. How do you rectify that?
Because just the fact that violating the Prompt Pay Act is grounds for discipline by the ROC does not in itself mean that only people who are subject to the ROC's regulation are subject to the Prompt Payment Act. Let me give you an analogy. I'm required to be licensed by the State Bar of Arizona. If I commit a crime, I'm subject to criminal liability. I can go to jail. That's also going to be grounds for me to be suspended or disciplined by the State Bar of Arizona. That certainly doesn't mean, however, that the criminal laws apply only to attorneys because attorneys are regulated. It's the same thing here. Yes, violating the law is certainly going to be grounds for suspension or grounds for discipline by the Registrar of Contractors, which is the body that regulates those who are required to be licensed. That doesn't mean you should confine the statute only to registered contractors.
But Mr. Peck, this is not the only statute you can collect under if the Prompt Pay Act does not apply to your client, unlike the criminal law and the regulatory body, etc. So, in your analogy, you break the law, you go to the pokey, you get prosecuted, and a report goes to your regulatory agency. I liken that to you have a breach of contract claim, you can collect, there are civil penalties and remedies already available to your client. The Prompt Pay Act was established and determined, according to legislative history, from my understanding of it, to protect Arizona businesses and to ensure that our construction industry operates smoothly. There's a difference.
Your Honor, I think that...
What am I missing? Just tell me what I'm missing.
I think respectfully what you're missing, Your Honor, is that perhaps had the parties not chosen Arizona law to govern, then this wouldn't be an issue, because we wouldn't have a basis for claiming the protection of Arizona law. But this is a case where FS&E deliberately chose Arizona law to govern the parties' relationship, and they can't pick and choose which laws are going to apply. There's plenty of laws that are enacted in Arizona for the benefit of its citizens. I'm sure that when the legislature passes laws, they're thinking about citizens of Arizona and not citizens of New Jersey or New York or any other state. But when you have parties that agree to be governed by a contract, and they say, this is a set of rules that's going to determine the enforcement and the interpretation of our contract, you're taking it subject to all of those rules. You're not just picking and choosing. And if one of those rules...
But if the law of Arizona requires the application of particular laws only to those who are regulated by the ROC, then the outcome would be different then.
Well, if the law was limited only to contractors who are registered by the ROC, then sure, the outcome would be different. Then we would lose. I mean, I think if the statute just said on its face, this applies only to contractors within the meaning of the general licensing statute, sure, we lose.
Haven't we held in first-order development that the Prompt Payment Act implies that a contractor within the meaning of the act must be licensed by the ROC?
Respectfully, I don't think that was the holding of that case. I realize that the court made that statement, but that statement really was not necessary to its holding. What that case was about was a definition of related to in the term construction contract. They said, look, how far are we going to stretch this term related to a construction contract? Is a guy that brings his food truck by a work site every day going to be doing work that's related to a construction contract just because he's on the site? No, that's not really the case here. This isn't an issue about are we related to a construction contract. The contract here, the primary contract, was an agreement entitled Maintenance Services Agreement between A&P and FacilitySource. That agreement touched on a whole lot of things, not just cleaning out grease traps, but plumbing, electrical work, repairing foundations. I mean, everything that you could think of. Clearly, that is a construction contract within the definition of the Prompt Payment Act, which includes maintenance of any building within its terms. Traps App had a contract. Excuse me. That hasn't happened before. It doesn't happen again. Traps App had a contract with FS&E. Therefore, they are a subcontractor. They performed a portion of that work. That puts them within the terms of this agreement. So you don't have the same question that you had in RSP, where you have to ask, how broadly are we going to define this term related to? And they don't. FS&E doesn't challenge that this that subcontractor agreement between Traps App and itself is at least related to a construction contract. So while I do understand that that was something that the court said in the course of deciding RSP, I would submit that it was dicta. And I with respect to the court and your colleagues, I do think that there are also reasons to conclude the opposite, that the fact that the statute chose to define terms differently than the licensing statute actually implies just the opposite, that it wasn't intended to apply solely to construction contractors and people who are licensed by the ROC. Your Honor, I've got 2 minutes left, so I'd only like to very briefly address one issue with respect to the appeal, and that is this argument that I touched on before, that what we did was illegal. It was not. The statutes that they're citing are statutes relating to garbage haulers and operators of garbage dumps. That is not the type of work that TrapZap did. They cleaned out the grease from grease traps. They left it on site, and it was disposed of, thrown in the trash by AMP, who presumably had its own contract with garbage haulers, or perhaps FSNE had a contract with the people who'd come and take that stuff to the dump. We didn't do it. On the occasions where we had to pump out grease from high volume grease traps, that work was subcontracted out to contractors who are licensed to pump and haul grease. So it wasn't within the scope of the work that they did. I know FSNE makes this argument that, well, if you subcontract this work, then you also have to be licensed. You can't evade the statute that way. That shows, I think, a real lack of self-awareness on FSNE's part, because their whole job is subcontracting with people who do work for which you may need to be licensed.
So is that a material fact that needs to be flushed out, or do you think it's sufficiently addressed in your briefings and evidence?
No, I think it's addressed in our briefings and evidence, and I don't think there was any evidence that contradicted that. Going back to the statement of facts in support of our summary judgment motion, there wasn't any evidence that we did anything other than A, clean out grease traps, and B, if there were grease traps that needed to be pumped out, that was work that we subcontracted. There is no dispute as to those facts, so summary judgment was appropriate there. And it looks like I've lost my time for rebuttal, so I'll simply conclude by saying we would respectfully request that this court affirm the judgment in favor of TrapZap on its breach of contract claims and reverse the trial court's dismissal of our claims under the Prompt Payment Act and remand with instructions to award interest on our contract damages at the 18% rate provided under the Prompt Payment Act. Thank you.
All right, thank you. Mr. Brophy, any final words?
Thank you. Very briefly on the prompt pay issue. The position that TrapZap is taking, and it's important to remember that at bottom, this is about whether or not prompt pay interest is owed. And what they're saying is, we get prompt pay interest under the Act, even though we're not subject to any of the other Act's regulations, including licensing, discipline, anything like that.
Is it your view that this is a construction contract or not?
No. You just heard him say that he's removing, grease from waste of some kind from a container within the building. I don't know that that qualifies as even maintenance of the building itself.
Are there other portions of the contract that would bring it within a construction contract?
Not that I'm aware of, and it was we went through this a little bit because there was a mechanics lien issue on an issue that was already resolved, and there wasn't any work being done on the building itself. There wasn't. I mean, this was all waste removal. There wasn't repairs or improvements to real property or to the building. That was the position that we took, and that was resolved at the trial court level. While you do look at the language of the statute, this court has said previously the provisions of a statute have to be read and construed in the context of related provisions and in light of its place in the statutory scheme, and where it is placed gives guidance to the meaning of the statute. I'd like to conclude on this issue just by saying that let's take a step back and assume that the Prompt Pay Act did apply. There are two cases, Baker and Kenyon, where decided under Arizona law, this court has said, well, if the work's performed outside of Arizona, then the reach of the Arizona legislature doesn't go that far. It's for the protection of the Arizona public. It is to protect the public from unscrupulous contractors performing work within this state. So I believe one subcontractor was in Mexico and one was on the Arizona residence, but the work was done in Mexico and on the Navajo reservation, and in both cases this court said that the Prompt Pay Act doesn't extend that far. If I can conclude briefly going back to the illegality issue, if the court decides that the statutes at issue at least in the states where they were enacted, were for the health and safety of the public, then in writing its opinion, if the court is going to conclude that that is not the line
Is there
that runs...
anything in the contract that would prevent them from subcontracting to licensed contractors to perform the duties that you say they didn't have their own license for?
They are not allowed to subcontract without our permission. There is a contract provision that says that. There is also a contract provision that says that they will ensure that both they and their subcontractors, if any, will be appropriately licensed.
And do you have anything in the record that says that their subcontractors that they hired for waste hauling were unlicensed?
Yes, that issue was raised at the trial court level. They submitted a number of licenses from subcontractors that they claimed did the work for them. We objected because there was no foundational evidence and they were disclosed late. In making his ruling, Judge Brodman didn't really rule on our motion to strike and didn't really mention as part of his decision that, well, the subcontractors were licensed anyway. So I don't really know that I have a complete answer to you. I don't know how you...
So you filed a motion to strike?
Yes.
And he never ruled on it?
Yeah, he never really
You know
addressed...
what the presumption is then, right?
He denied it.
He denied it.
Okay, well, I mean, but he also didn't rely on the fact, I mean, all I'm saying is that it wasn't, the fact that subcontractors were licensed, that's not an issue that's raised in his minute entry, is the only thing I was trying to say. I am out of time unless anybody has a question.
All right, thank you very much.
Thank you.
Thank you, counsel, for your fine arguments here today. The matter is deemed submitted. We'll issue a decision in due course.